Crime has been called the most relevant aspect of law. Criminal law is the most likely discipline to feature in the day-to-day lives of people, and yet knowledge in this area is severely lacking. For the purpose of law enforcement, a robust police and judicial mechanism has been created, but it is your responsibility to know how to set this machine in motion. Ignorance of law is no excuse, as a citizen has an implicit duty to know the rules and regulations of the place they reside in. Luckily, Amicus Curiae is here to help you along. There are many aspects of criminal law relevant to the common man, but today we will start with the basics.
In this video, you will learn to report crimes and similar disturbances to the police. By the end, you will know the basics of what a GD, FIR, NC and complaint are, their uses and the basic procedure of how to file them. You will also know your rights regarding each.
Before we begin, be sure to hit that like button, don't forget to subscribe to the channel and press the bell icon to stay updated with the latest news from Amicus Curiae.
The first thing we need to know when filing a report with the police is the concept of the GD or General Diary. The General Diary acts as a police station's logbook. The day-to-day happenings of the station, such as complaints, arrests, seizures, etc., are recorded in it as and when they occur. The police manuals of the various states decide the exact details of what to record in the GD, but it universally includes complaints, charges, names of arrested persons and complainants, and seized weapons or property.
The primary provision for it can be found in Section 44 of the Police Act 1861, which states that it shall be the duty of every officer in charge of a police station to keep a general diary in such form as shall, from time to time, be prescribed by the state government. The GD is an internal record and has no legal value. It cannot be used to start an investigation as is. However, it is proof that the station has received certain information or persons. The magistrate of the district may inspect the GD of any station under his jurisdiction at any time.
General diary entries are filed when you have no need or desire to start a criminal investigation into a matter, but something must be brought to the attention of the police. For example, if you lose some item, especially sensitive things like documentation or mobile phones, a prompt entry in the diary may serve as proof of your innocence in case it is misused down the line. Other cases include if unnatural movement is noticed in the area, if someone disappears for a long time without explanation, or if some persons are creating a disturbance or nuisance in the area.
Though it is not a legal police report, the police must still take action on the basis of a GD entry, such as warning any disruptive elements or starting a missing person investigation.
A general diary entry can only be filed in the station having jurisdiction over the area. It must be taken free of cost and reduced to writing in the prescribed format if given orally. If a police station refuses to file a GD or asks for money, a complaint can be made in writing to the superintendent of police having jurisdiction. In a commissionerate area, the commissioner of police is the equivalent authority. Usually, big cities like Kolkata and Mumbai are police commissionerates.
You as the informant are not legally entitled to a copy of the general diary entry. The station may refuse to give it or charge money for it. However, if the entry is filled in writing, you may bring a copy and get it signed and stamped by the station house officer as proof. In the case of Superintendent of Police CBI and others versus Tapan Kumar Singh, the Supreme Court held that a GD entry disclosing the commission of a cognizable offence may be treated as an FIR. And that brings us to the FIR, or First Information Report. But before that, you must understand the concept of cognizable and non-cognizable offences. A cognizable offence is defined in Section 2 of the Criminal Procedure Code as an offence for which a police officer may arrest without warrant. Most serious offences such as theft, robbery, murder or rape are cognizable offences. The police require no prior permission from the magistrate to begin an investigation into such an offence. On the other hand, less serious offences such as criminal intimidation, assault, cheating or forgery are non-cognizable offences. The police need the permission of the magistrate to investigate such cases, and they cannot make an arrest without applying for and receiving an arrest warrant.
Unlike the general diary, the first information report is filed with the express intent to begin a criminal investigation into the matter. The person filing the FIR, in this case you, is known as the informant. Whenever we see or hear about a crime, our first instinct is to say, let us file an FIR, but the reality is a little more complex. The provisions for the first information report are included under section 154 of the Criminal Procedure Code, which deals with the receipt of information in cognizable cases. Thus, an FIR may only be filed in respect of a cognizable case, that is, a case where at least one offence committed is cognizable in nature. The informant may be any person who has knowledge of the crime, and not necessarily the victim themselves. It may be friends, family, a complete stranger, or even a police officer who has obtained knowledge that a crime has been committed.
Like a GD, you can register an FIR orally or in writing. If given orally, the station house officer is duty bound to reduce it into writing. Once the written report has been made, it must be read over to you. Once you are satisfied, you must sign the document. A general diary entry verifying the receipt of information is made, and a certified copy of the FIR is handed over to the informant as a matter of right.
In case you are a woman who is the alleged victim of rape or some other sensitive offences, your FIR must be registered by a woman police officer. Further, in case you as the victim are mentally or physically disabled, you may choose to have the report registered at your residence or any other convenient place, in the presence of an interpreter or special educator. It is not necessary to register an FIR in person at the police station, though doing so in writing is preferable. In an emergency, the police can register your FIR via means of a call or even an email. In the modern era, all police forces also have their own online portals to simplify the process. But what exactly do you have to put in such a report?
Many people have the wrong idea about what an FIR should contain, such as the name and address of the accused, exact penal section of the offences, or complete and accurate details. The truth is that none of these things are necessary to register a report. An FIR does not need to go into minute details or name any perpetrators or offer any concrete evidence. All that is required is that the information discloses the commission of a cognizable offence. The police are bound to register any FIR. The truth of the contents cannot be verified in the pre-investigation stage. The only preliminary inquiry that can be conducted is to ascertain whether the information reveals a cognizable case. However, it is beneficial to the investigation if all known details are provided at the reporting stage. Minor discrepancies in your narrative are not enough for the police to refuse to file a report. But what do you do if the officers on duty keep shuttling you down between stations as the crime is not within their jurisdiction?
Police stations often take the excuse of lack of jurisdiction to avoid taking an FIR, as it constitutes extra work and burden for them. It is true that filing the report in the correct jurisdiction is recommended, but it is not compulsory. In case the exact jurisdiction cannot be determined, or if you simply find it more convenient, an FIR for any offence may be registered in any police station, notwithstanding jurisdiction. Such an FIR is called a zero FIR, as the report is assigned the ID number of 0. After preliminary investigation, the police station must forward the FIR to the SHO having appropriate jurisdiction over the offence. The receiving police station will assign a proper ID number to it and proceed with the investigation. But what if they refuse to take the FIR entirely? The police can refuse to file your FIR for legitimate reasons, such as if the offence revealed is too petty and trivial, or if the offence is non-cognizable in nature, or if no offence is made out at all from the information provided. However, whenever the informant reveals a cognizable offence, they are duty bound to register the report. If you believe the station has wrongly refused to take the FIR, you may approach the superintendent or commissioner having jurisdiction with a written application containing the substance of the report. If the superior officer feels it is valid, he may investigate the case himself or order his subordinate to register the FIR and begin investigation. If even the SP refuses, you may approach the judicial magistrate or metropolitan magistrate with a complaint. If the magistrate takes cognizance of the issue, he may order the police to investigate the case.
In the case of Lalita Kumari vs. State of UP, the Supreme Court held that filing an FIR is compulsory if the information reveals a cognizable case. Thus, a police officer wrongfully refusing to do so faces up to 6 months in prison for civil contempt of court. A letter to the Chief Justice of the Supreme Court requesting him to take cognizance of the matter may be filed to initiate contempt proceedings. Under Section 166A of the Indian Penal Code, refusal to file FIR in sensitive offences such as rape is punishable with up to 2 years of imprisonment and fine. The police must conclude the preliminary inquiry into an FIR within 7 days. In case the reporting is closed after this inquiry, they must provide a copy of the GD entry recording closure to you free of cost. All other facts and processes must be noted meticulously in the diary as well.
What if the offence is non-cognizable? The police have no authority to investigate a non-cognizable case without the sanction of the magistrate. If the station receives information about a non-cognizable offence committed within their jurisdiction, the SHO will make an entry in the GD to that effect, known as an NC or non-cognizable complaint, and direct the informant to the appropriate magistrate. To begin investigation into a non-cognizable offence, you must make the magistrate take cognizance of the case by means of a complaint.
According to the CRPC, complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this code that some person, whether known or unknown, has committed an offence. Simply put, it is the disclosure of material facts to the magistrate with the intent of making him take cognizance of the matter. There is no format prescribed for the complaint under the CRPC, but you should take the help of a lawyer to draft the documents in adherence with court standards.
Once the magistrate receives your complaint, he shall apply his mind to it. If he feels that the facts disclose a case that merits looking into, he shall take cognizance and pass an order directing the police officer having jurisdiction over the case to begin an investigation. Henceforth, the police proceeds as in a cognizable case, except that a warrant is required to make any arrests. A police report to the magistrate is not ordinarily counted as a complaint.
However, when an investigation into any received complaint reveals that a case is actually non-cognizable in nature, the officer must submit a report to the magistrate and cease the investigation until an order to continue is received. In such a case, the report may be treated as a complaint and the reporting officer as the complainant. If the magistrate wrongfully dismisses your complaint, you can file a petition for revision before the Sessions Court or the High Court. But what can you do to keep track after your complaint is filed?
According to Section 74 of the Indian Evidence Act, any documents recording the acts of official bodies or public officers are public documents. Thus, the general diary of a station is a public document. The station house officer is bound to give a certified copy of the GD entries to you if you make an application for the same, upon payment of the requisite fees as per Section 76 of the statute. Similarly, the Supreme Court has also held the FIR to be a public document and directed that it be made available for inspection at the police station. The accused in a case is entitled to get the certified copy of the FIR within 24 hours of filing an application with the police as per Supreme Court guidelines. Alternatively, these documents as well as others such as the final report or charge sheet of the investigation may be obtained by filing an RTI application with the concerned police public information officer. Information as to their identity is usually available upon enquiry at the local police station or online.
In every case, the investigating officer is bound to maintain a case diary, wherein the details of the investigation are recorded. This is a privileged document. Neither the accused nor his agents can receive a copy or examine it in very specific circumstances. However, the informant or any other person may obtain extracts by the means of an RTI application. Thus, the mechanisms of RTI and public documents provide an important tool to keep track of the progress of the investigation into a case. You can similarly refer an application to check the status of a letter of petition of contempt proceedings or that of a complaint filed before a magistrate. In Youth Bar Association of India versus Union of India and others, the Supreme Court held that copies of all FIRs filed in a police station shall be uploaded to the website of the police station or, if one does not exist, to the website of the state government within 24 hours of registration. The time may be extended to 48 hours for some unavoidable difficulties and to a maximum of 72 hours only in the case of connection problems. The only exceptions are FIRs declared to be sensitive by an officer of rank not below Deputy Superintendent of Police or an equivalent. In some states, the district magistrate is also empowered to do so. An application for certified copies may also be made to the court where the report is forwarded at the beginning of the investigation as per Section 157 of the CRPC. And the same shall be fulfilled within 2 working days in a non-sensitive matter and within 3 working days in a sensitive matter.
In any case, after the police investigate, they must file a final report before the court. If the evidence is insufficient to constitute a proper case, they file a closure report. And if they think that they are able to proceed against the accused, a charge sheet is filed. You are entitled to receive a notice regarding the filing of the final report before the court as the informant. What happens next is another subject altogether. We will discuss those topics in a future video. For now, we hope you enjoyed this one and maybe learned something too. Do you now feel confident enough to approach the police when you need to report something? Let us know in the comments.
As always, if you like this video, be sure to like it. And if you wish to keep watching informative, concise and fun explainers like this one, press that subscribe button and hit the bell icon. This was Amicus Curie and thanks for watching.